Metro Nashville Transportation Licensing Commission committee meeting. What we're going to do is we start off most meetings by giving the Pledge of Allegiance. So if we'd all stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I guess right out of the gate, one of the things that we want to do is to acknowledge our former chair, Helen Rogers. She will no longer be serving as the chair of the Transportation Licensing Commission. But as a commission, I think that we all would like to commend her on the record for her years of service to this commission, and I'm sure that you all wish those same sentiments to Ms. Rogers. And so I just wanted to make that acknowledgement initially right out on the record. We always start off all of our meetings as well with the notice of appeals, and I'll read that out for you. Pursuant to the provisions of Section 2.68030 of the Metropolitan Code of Laws, notice is hereby given that if you are not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. We have a relatively short agenda. We haven't approved the minutes. Would anyone like to make a motion on the approval of the minutes?
Make a motion that we approve the minutes from the last meeting.
Do we have a second? Second. All those in favor?
Aye.
Aye. We have a relatively short agenda. We'd like to turn to item number 4. Mr. Fields, this deals with the HR letter to the Transportation Licensing Commission.
With the Commission's permission, I'd like to read the letter into the record. This is a memo from Jim Kramer, the Deputy Director of Human Resources. It was dated October 2nd. The subject is disciplinary meeting. On September 28, 2012, a disciplinary meeting was conducted by Byron Rizal, Roy Jones, and Velvet Hunter. The meeting was facilitated by Jim Kramer of the Human Resources Department. After conducting the disciplinary meeting for Mr. Bowling, Mr. Morris, and Mr. Lawhorn, the panel unanimously recommends the Transportation Licensing Commission impose no discipline on these employees. The panel members' recommendation considered the following. The investigation found, and these employees confirmed, that they were expected by their supervisor to carry the badge and the gun. Evidence supports that the badges have read Nashville Police or Metropolitan Police for as long as anyone can remember. The director confirmed these employees were issued badges. They did not obtain the badges in a surreptitious way. These employees claimed, and the director supported, that they were not covert about their Nashville Police badges or handguns. Both were openly carried for years in meetings with police officers before their commission and with their supervisor's approval without being challenged. In light of these concerns, panel members believe it is unreasonable to expect these employees to have been aware of policy infractions.
With that item read into the record, there's no need for approval. Are we okay?
Mr. Chair, action is required to, and I'll defer back to Metro Legal.
Yes, Mr. Chair. The previous action of the commission, which is the appointing authority for the inspector,
yes,
had been to ask that the substantive review of the allegations against the employees be delegated to the Department of HR to form an independent panel that would come back to the commission with these recommendations. But as the commission is ultimately the appointing authority, the commission does have to accept or reject the recommendation of the hearing panel.
Okay. Commissioners, do we have a motion on the floor?
I make a motion that we accept the recommendations.
Do I have a second?
I second.
All those in favor?
Aye. Aye.
Aye. Opposed? Motion passes. We will now turn to item number 5 on your agenda for today, to the application for the driver's permit of Mr. Farrell Oles. Mr. Oles?
Yes, sir.
Can you step up? Mr. Fields?
Mr. Oles has applied as a record driver. And we reviewed his record, and he revealed that he had had some issues in the past. The charges and/or convictions which would have precluded him from being a record driver are outside the 5-year limit. However, there are several of them. In those cases, based on the direction of the commission, we determined that we needed to bring it to you to consider the issuance of the permit.
Yeah. Commissioner, any questions for Mr. Oles?
Mr. Oles, I have a question. Looks like on August 16th, 2011, you were charged with a DUI and assault with reckless endangerment. Is that correct?
No, not an assault. I was charged with a DUI, and after going through court and proceedings and everything, it was lowered to a reckless endangerment, not a reckless driving or anything like that. It was more of a like a domestic argument that went wrong. I was driving after I had consumed some alcohol, but it wasn't like I didn't get pulled over or anything like that. I had actually called the police to my house myself, and it's just, unfortunate incidents.
Mr. Oles, it shows on your application that you will be employed by Express Towing. Is there anybody from Express Towing?
Yes, sir, I do. I have Irby Trotter with me from Express.
Is there anything you'd like to say, sir?
I've known him now for about 5 years. He was partners at a mattress delivery company, and I done work on his truck, and he's been an outstanding man since I've known him. Everything he's told me he's done. I mean, I have no reason not to think that he wouldn't make me a good driver.
Okay. Thank you, sir.
Thank you.
Mr. Oles, do you have anything to say?
Other than I would definitely like the opportunity to be able to get my permit so I can, I guess, start learning and, be a record driver. I realize I've had my run-ins with the law and stuff when I was younger. Take some people longer to grow up, I think, I've definitely had a change of heart, and I do everything in my power to be an upstanding citizen.
Well, you have to recognize that part of what we do in this commission is we legislate for the public safety. So a lot of these concerns go directly to the public safety of the citizens of Nashville.
Yes, sir.
I don't personally have a vote on this one way or the other, but that's something that you really need to, one way or the other, keep in mind moving forward, is that you have an extreme responsibility, if we were to grant you the permit, to move forward and recognize your responsibility to the public safety.
Yes, sir. Like Mr. Trotter alluded to, for the past 4 years, I've been a co-owner of a delivery service. We've never had any complaints as far as, putting anyone in harm's way or anything like that. We're, professional service, everything like that. The company I was contracting for actually went under. That's why I'm looking to pursue this avenue here as far as to be a tow truck driver.
Yeah. Commissioners, any further questions? Commissioners?
And I need to go back to the August 2011 issue. On the reckless endangerment charge that you pled guilty to, did that have anything to do with driving, or was that, because that's unclear from the record here?
It's kind of conflicted. Like I said, I was charged with the DUI. I wasn't pulled over. No one even witnessed me driving my car. I volunteered the information that, yes, I drove myself home. Like I say, it was more of a domestic thing. The woman that I was living with at the time was threatening to damage a lot of my property and stuff like that, and I drove home. Like I said, after the proceedings and everything, they decided to drop it to the reckless endangerment as opposed to DUI because I did, I volunteered all the information that I got in trouble for,
Was anyone in the car with you when you were driving?
No, sir. No, sir.
Any additional questions, or we will certainly entertain any motions? Anytime you would like to make a motion, commissioners.
I'll make a motion. Mr. Olds, I don't make this motion lightly. Given your record, I'm just not satisfied that your application is a good one to approve. And with that, I would make a motion that we deny the application.
We have a motion on the floor for denial of the application. Do we have a second? Motion fails. Do we have any further motions?
I will make a motion that we grant the license for 1 year, restricted to express towing. Can I start over?
Absolutely. It's your motion. It's not on the floor.
Let me ask, do we as a body ever do drug testing at all? Do we do drug testing at all, or is that incumbent upon the employer?
We can stipulate, can we stipulate that we require drug testing?
Yes.
Yeah, that's been and historically the commission has had that. Typically the company would be responsible for random drug testing and regular reports back to the commission.
Okay. Sir, are you willing to do that? All right. And the reason I'm going to make this motion based on that is
Yes,
because
sir.
of some of the priors I said.
Yeah, I totally understand, sir.
I make a motion that we grant the license with the caveat that there are 2 random drug tests within the first year, and he's reprimanded to express tow for that period. And that's the motion.
I second.
Okay, so we have a motion that's on the floor and seconded for 1 year, restricted to express towing with random drug screenings, 2 of them.
Yes.
Okay. All those in favor?
Aye.
Aye.
Opposed?
Nay.
Motion carries. Congratulations, Mr. Olds, and
Thank you so
do
much.
not take your do not take
No, I
this
promise
lightly.
I won't.
Please do not.
Thank you.
Nice. Let's move to item number 6. The application for a driver's permit is Francis Okonkwo here. Not here? Okay, commissioners, do we have a motion? Traditionally, in this situation,
I make a motion that we deny the permit.
we have a motion on the floor. Do we have a second?
I second.
All those in favor?
Aye.
Opposed? Denial motion passes. Spoke too low.
I just wanted to make sure what I was looking at.
Okay, now we have item number 7. Do we have Sugar Creek and its representatives? Can you step forward?
We do, Mr. Chairman.
All right. Mr. Fields?
I'd like to turn over to Metro Legal.
I'm just going to ask that the commission allow me to recuse myself from this one. I've been involved in assisting staff with the preparation, and so we've just out of an excess of caution decided to bring in a couple of other attorneys from Metro Legal. Ms. Gallimore Scruggs is going to be the independent advisor to the commission, and Mr. Michael is going to assist staff with presentation of the case.
All right. Commissioners, do you all understand that Ms. Gallagher Scruggs is for the commission?
Mr. Chairman, can I ask about some procedural matters about how you wish to conduct this?
Could you hold for just 1 second? But yes, you certainly can, sir. Would you like to introduce yourself?
Gary Blackburn, attorney for Mr. Smith in Sugar Creek.
All right, go ahead, Mr. Blackburn.
The first question is, do we have the rule? Ms. Rogers understands what the rule is. That's the sequestration of witnesses during the testimony of other witnesses. That's standard in most proceedings. And I don't know the extent to which this proceeding has that level of formality. That's why I'm asking.
Ms. Gallagher Scruggs, can you please assist the commission with this?
I don't see a problem with that. Mr. Michael?
The city would know that it plans to call a robust total of 1 witness, and if it would be of any assistance, the council would be glad to stipulate and invite that witness to step out during other testimony. But as we don't plan to call a witness, if that will be of accommodation to Mr. Blackburn and his clients, that's fine with us.
Well, no, I assume that witness would be first.
That seems to be the
So the rule wouldn't apply in any event. So that's a moot question.
Absolutely.
Secondly, we will have some motions to make. I understand that there's no formality about that either. If I'm incorrect about that, then I'll do it your way, not my way. But I do need to know the context within which we do this. We have some things that we would like to actually provide subsequent to this meeting in terms of a memorandum.
Subsequent to the meeting?
That's right.
Well, we have things that we're going to make decisions on the record, so...
Well, then we object to that on the record. I respect your ruling. Don't misunderstand me, but we object to that. There are serious legal issues involved in what we're doing here today, and if I can't present those, then my client's being deprived of procedural due process. Now, you understand, Ms. Rogers and I've known each other for many years. She'll understand that I don't mean this is aggressive. I mean, this is what I'm here to do. This is what I must do, and it's my duty to do it, and I am going to do it. There are several of those things to mention. Also, I would note for the record that a proceeding like this, we don't have any discovery. We don't have the ability to depose witnesses in advance, this type of thing. I just wanted to confirm that. That's my understanding.
That your understanding of that is correct. We will have to respectfully agree to disagree regarding the scope and the exclusive jurisdiction of the Transportation Licensing Commission over the matters that are set. Ms. Gallagher Scruggs, can you help us out with this? We're assuming what your issue may be, but maybe can you clarify what your issue is regarding our ability to render a decision in this matter? Just so we're on the same page with where
Sure. Well, there's more than one. There's more than one thing. We have stated in prior correspondence in this that the charges against Mr. Smith are unconstitutionally vague. That the authority cannot be fully determined without determining with more precision exactly what he's charged with doing. Secondly. If I understand correctly, what Mr. Morris will testify to, he's speaking of certain matters that he alleged to have occurred on March the 3rd of this year. Those matters were the subject of Metro Ordinance violation citations, which he issued ultra vires. He had no authority to do it. So we initially objected to defending both of those, that is, defending the ordinance violations as well as this proceeding, however we may characterize it. This is a threat to deprive an individual of an interest in property, and so that's why we're talking about due process. We objected to that. So this hearing was postponed. On August the 3rd, we appeared in General Sessions Court, and my colleague here appeared with us. And Mr. Morris testified. Once Mr. Morris testifies, then jeopardy attaches. And then thereafter, the metropolitan government dismissed all of those ordinances. That means, as a legal matter, Mr. Smith was acquitted.
Not ordinances, tickets.
Well, ordinance violations are tickets. The tickets were dismissed, alleging ordinance violations after a witness was sworn. That means that those charges are barred forever. Now, what we're doing today is we're proceeding under the same set of facts with another agency of government attempting to make a deprivation of a loss of property. So what we've argued, and argued with the Chancellor this morning, was that this constitutes both double jeopardy and res judicata, because the metropolitan government was the party, and this is the metropolitan government. So we have the res judicata argument to make. Chancellor Perkins has said, well, we can't show irreparable harm. And given his explanation, I suspect he was correct about that. Not quarreling with him. I would never quarrel with him. So there we are. But the whole matter of the vagueness of these charges is a separate issue from the fact that these issues have been determined with finality by a court. And now we're here facing another deprivation of property based upon the same allegations. Now, we also would have a substantial amount of testimony. We would have some available today, but we'd have quite a bit if we had a full-blown hearing about disparate treatment, particularly about bias regarding the manner in which these matters are set up and prosecuted, whether you start with the question of whether a U-turn is even prohibited, but the evidence will be absolutely clear that that is a routine practice, sometimes even directed by police officers, and that does not constitute a violation. And if it did, then there's a plain equal protection issue here because of selective enforcement. The law is very clear about selective enforcement. And so those are the types of things that I suspect, if I were you, I would have very little interest in hearing that type of thing. That being the case, I think we're entitled to raise those issues, and we do, and we want them raised for the record.
They have been raised for the record. Would Representative from Metro like to speak?
Sure. Good afternoon, members of the board. My name is John Michael. I'm an attorney with the Metro Legal Department. I'm just here to help present the facts of the matter with regard to the charge that's been brought before this board involving Sugar Creek Carriage Company. A very brief response to some of the issues that I understand opposing counsel needs to make for the benefit of the record, and I recognize that that's important for him to do so. The matter that was brought previously to the Environmental Court in General Sessions Court here in Davidson County involves some actual citations that were written. And it's correct to say that those were in fact voluntarily dismissed by the metropolitan government after limited testimony was taken from the inspector, Mr. Morris, with regard to a preliminary argument that opposing counsel brought involving the propriety of the issuance of those citations. Then get into the whole business of what happened that day and whether or not the actions taken by the carriage company were in fact violations of the rules of this commission, or more importantly for that hearing, violation of the Metropolitan Code of Laws. Instead, a preliminary matter, a technical matter, if you will. Ruling was never made on that technical motion because the government voluntarily dismissed the matter. What was before, or what was at issue in that environmental court proceeding was a fine. The end result, if that had gone all the way through and say, for example, the court had found the drivers to be guilty, would have been a fine, a monetary fine of $50 in court costs. If the board hears this matter and decides that the facts represent a violation of the Metropolitan Code of Laws or the Commission's rules for conduct of the horse-drawn carriages, then we're talking about the regulation of the industry, specifically this company, and subsequently any effect that may have on their certificate or licensure with this commission. In one case, a fine. In another case, the regulatory scheme. Two different issues at stake. That's one of the multiple bases by which we think what amounts to being a res judicata argument, or, hey, you can't try the same thing twice in front of government entities, doesn't fly here. That's part, though not all, of why the Chancellor shot down that argument earlier this morning in Chancery Court. And that's part of why we think you should go ahead and proceed with your hearing. And we'll go ahead and let you hear a little bit about the facts of the case and let you make the determination, do we think this constitutes a violation or not? And if so, what do we do about it by way of punishment?
Does that help clarify your procedural?
I don't have any questions. Commissioners, are there any questions for either counsel? All right, we are okay. Considering that, and I may have to defer to, but considering that this matter deals with Johnny Smith and Sugar Creek in his own violations as well as Sugar Creek's, they arise from the exact same set of facts, so we can present the evidence at one time, correct? Rather than to do things separately, or how would?
The only agenda item that received notice was the certificate issue. So that is the only issue that procedurally should be dealt with today.
Okay. That was Metro.
Metro intends to only call one witness, Mr. Howard Butch Morris.
Mr. Morris.
What's the best way to get out of the way here, Karen? Forgive our informality, if you will, members of the board. I'll just ask a few questions, Mr. Morris. Mr. Morris, as you know, I'm going to ask you a few questions about an incident that took place back in March of 2012. Would you begin by stating, for the benefit of the record, your name and your position with Metro?
Howard Morris, and I'm an inspector with Transportation Licensing Commission.
Okay. And are you, in fact, familiar with the matter that we're bringing before the board today?
I am, sir.
Okay. Now, I made reference to an incident on March the 2nd of 2012. Were you working that day?
Yes, sir.
Okay. And can you tell me where you were when you became involved with whatever came out of this incident?
I was in a pickup with dark windows that was down between 1st and 2nd on Broadway, kind of between Big River and the old Acme feed store.
Okay. Excuse me, Mr. Chairman, I don't believe the witness is sworn, is it?
I think not. Is that a custom of this board?
I don't believe it's a custom of this board to swear the witness in.
You're going to deprive someone of his property with unsworn testimony? Is that your procedure?
Procedurally, this is not a deprivation of property.
This is a regulation issue.
You're not going to swear a witness. We object to all the rest of the proceedings on that basis.
Objections on the record.
Mr. Morris, what did you see that day?
That day I saw Sugar Creek, Mr. Smith, throughout the time that I was there, from approximately 10:30 to 4 p.m., 10:30 a.m. to 4 p.m., make 4 U-turns right there at the intersection of 2nd and Broadway, which was also a deviation of the route 4 different times.
Tell me a little bit about that when you say the deviation of the route. What do we mean by that?
There are routes set up for the horse-drawn carriages to follow, and that route coming by me actually comes all the way down Broadway, then goes down to Riverfront and makes that U-turn in that kind of half roundabout, and then goes back up to their carriage stand.
And if you could remind us, where did you see these U-turns as you described them take place?
At the intersection of 2nd and Broadway.
Okay, now, separate and apart from any question about traffic laws or anything like that, do I understand what you're saying to be that that's some sort of a violation of the deviated route rule that the commission has in place?
Yes, sir, that's my understanding.
Okay. And just for the benefit of the record then, you turn at the intersection. That's not illegal in every situation necessarily, is it?
That's correct.
You and me in a regular car
leading, please.
That's correct.
Should testify for himself.
Again, this is a far less formal proceeding than you would like to make this, Mr. Blackburn. Let's just please allow the witness to testify. And you'll have your opportunity to question him as well.
Mr. Morris, on the occasion that you observed these U-turns, were there other cars in the immediate presence of the carriage?
Yes, sir.
Pedestrians?
Yes, sir.
Okay. Mind us getting, how many of these U-turns did you observe?
4.
Okay. Double check my file.
For the whole day, there were 5, but for what you're talking about, there were 4.
Can you speak up for the record?
I'm sorry. For the whole day, there were 5, but for what he's speaking about right now, there were 4.
Mr. Morris, you've given us your sworn testimony as to what you observed. Did you get a chance to capture any photos that day?
Yes, sir, I did.
Okay, and Mr. Chair, I don't know if that is part of what is included in your packet. Are the photos part?
We do have several photos in the record.
All right, Mr. Morris, are you familiar with the photos that have been submitted by staff to the board?
Yes, sir. Yes, sir.
Are these photos the photos that you took?
Yes, sir.
On that day?
Yes, sir.
This is part of your job?
Yes, sir.
Okay. In the absence of any need for formal authentication beyond that rather cursory authentication, I would ask that those be considered part of the formal record.
They are part of the formal record just by the distribution to the commissioners.
Chairman, I would subject that haven't even been tendered to the what amounts to the defendant.
Mr. Fields?
Those photographs have been sent 3 times. Twice for some.
For the benefit of the record, this would be glad to make that full of our standard.
So I want to make sure we're clear. We're going to consider things that have not been made part of the record or authenticated by any witness. Is that what we're doing?
Again, sir, this is a hearing on a licensure, on a privilege, rather than...
I understand. I just want to confirm that we're conducting this hearing, not under oath, with documents that have not been identified by any witness. Is that what we're doing?
We are following our proper procedure, yes.
Well, you characterize it as proper. I just want to know. Is that correct? That's what we're doing? The Chancellor's going to...
We
I
are,
just want to confirm it. That's
she
all.
has confirmed that we are adhering to our proper procedures for this commission meeting. Any objections are preserved on the record, Mr. Blackburn, but can we please proceed and allow this matter to proceed? You will have every opportunity to question this inspector and to present your case.
Well, once counsel quits testifying, I will do that.
Mr. Blackburn, there's really no need to be insulting at this proceeding at this point.
I wouldn't think so. No, sir.
Mr. Morris, how do you know it was a Sugar Creek carriage that you were observing?
As you can tell by the photographs, and my camera had a small telephoto lens on it, you can see the name on the back of the carriage.
Separate and apart from the photos, were you able to make any identification separate and apart from the signage?
I was by the driver.
Okay. What do you mean by that?
Well, I noticed that one of the drivers was Johnny Smith.
Is Mr. Smith someone you had met before, seen before?
Seen before.
In the photos that you have submitted through staff and to the opposing party through staff, were you able to identify Mr. Smith specifically in the photos or just by sight on that day?
In the photos and by sight.
Okay, same question with regard to the signage on the vehicle. Were you able to identify just by sight that day or also in the photos that you submitted?
By both.
Okay. Mr. Morris, with regard to the route that you testified about previously, that you discussed previously, have you received any indication, one way or the other, whether Sugar Creek had any sort of specially granted permission to deviate from their normally approved route on that occasion?
No, sir, I have not.
Okay. Questions we wish to ask of Mr. Morris at this time. Certainly, with the board's permission, we would like to reserve the opportunity to ask him further questions that may become necessary after the cross-examination of the witness, if that's permissible.
That would be permissible. Mr. Blackburn?
Thank you, Mr. Chairman. Mr. Morris, I just confirmed for the record that you did appear in General Sessions Court when these citations were prosecuted.
No, sir.
You weren't there?
In General Sessions? No, sir. Environmental Court?
Which is a referee of the General Sessions judge. The Environmental Court is General Sessions, isn't it?
Well, for me, it's Environmental Court, sir.
Okay. Well, you did appear in order to seek conviction of Mr. Smith for violation of the ordinances as described in the citations that you wrote.
That's correct, sir.
I don't think we're disagreeing.
No.
And you testified, you were asked then, you were placed under oath, and you did testify.
Correct, sir.
And you admitted that at the time you did this, you had no authority, you were not a certified licensed police officer.
That's correct, sir.
Okay. You also issued about 10 of these in a short period of time on the same day.
That's correct, sir.
Yeah. And somewhat generally in 15 or 30-minute intervals.
I think it's somewhere around 45, isn't it? 30 to 45.
Well, 12, 30, 1, 15, 2, and 3.
Yeah.
That's what I have jotted down.
So somewhere around 40, yeah, that's right, sir.
Okay, how many others did you issue that day?
That was the only one, sir. That's the only ones I saw.
You didn't issue any other citation to any other operator?
Yes, to Miss Peggy Sisk.
Well, another employee of Mr. Smith.
Right.
But other than Sugar Creek, you issued no others that day?
That's correct, sir.
Now, let's talk for just a moment about those that you did issue. You had two headings, as I recall. One was U-turns, and the other was approved route.
Correct, sir.
Okay. Is that the same thing?
Is it the same thing,
Is a
sir?
U-turn a violation of the route, or is there something separate?
To me, it would have been something separate.
Well, is there different behavior constituting those things?
Again, to me, you're talking about two separate issues, but if you're asking were they done at the same time, that would be correct, sir.
Well, you have one ticket, for example, that talks about disobeying a traffic law.
Correct, sir.
All right. And that's the U-turn.
Correct, sir.
And it's the U-turn that also is the alleged violation of the route guidance.
Yes, sir. Once it's made, is a violation of the route.
So one act constitutes two violations the way you wrote it up.
Correct, sir.
But you wrote nothing up for anyone else that day.
No, sir. I saw nothing else from anyone else that day.
Right. How long have you had a relationship with Hat Creek?
A relationship, sir?
Yes, sir. You ever ridden in their carriages?
Yes, sir.
Do you have
one time.
In Mr. Smith's carriage?
No, sir.
Do you know those individuals that are principals in it? They're drivers?
Do I know them to meet them? I did, sir, when I was directed by my director to go down there. Yes, sir.
You talked about deviation from a route. What route are you talking about? Where can we see that? Can we read that and compare it to what you saw?
To my understanding, it's somewhere either in parking or transportation. Do I have it? No, sir.
Is that the best that you can offer these ladies and gentlemen, these gentlemen, is that you think it's there somewhere?
I was told it was there, sir.
You were told it was there?
By my director, yes, sir.
Just real quick.
Yes, sir.
So, as we're here today, you can't tell us specifically what route guidance in writing is in the hands of Mr. Smith that he would have known he was violating at the time he did.
That'd be correct, sir.
All right. Now, this U-turn part, I'm looking at code section 12.16.170. I'll be glad if anyone wishes to see this to give you a copy of it. But this says that a driver of any vehicle shall not turn such vehicle so as to proceed in the opposite direction unless such movement can be made in safety and without interfering with other traffic. Is that what you're talking about?
If that's the ordinance you're reading, sir, I understand what you're reading there. Yes, sir.
Well, it is. This didn't happen in a curve or it didn't happen in an intersection, right?
Yes, sir. It happened at the intersection.
It didn't happen within the intersection.
Yes, sir.
Mr. Blackburn, can you provide a copy of that?
I would be glad to. Excuse me.
Sure.
I apologize. I should have brought more copies of it, but that's the one as I understand it. Did anyone else violate that ordinance that day about the U-turn?
Again, if you're talking about different companies, no, sir.
No?
Not while I was there, sir.
Did you have a beard yet?
Not that I remember, sir. I don't have very much facial hair, sir.
Well, I'm looking on that.
So I don't have a beard. I can't grow a beard.
Well, let me show you some photographs that we will up to the extent authentication is part of the procedure. You know Matthew Clark?
I think so.
Driver for Hat Creek?
I mean, I have met all the drivers, and sometimes I still don't know all their names, sir.
Excuse me, Mr. Blackburn. Commissioners, the section that he's referencing is on the last page of the packet in the event.
Yeah.
Okay, Mr. Blackburn.
Do you use social media, Facebook, Twitter, those types of things?
A little bit, not very much.
Are you Facebook friends with any of the persons with Hat Creek?
No, sir.
You're not? You sure?
To my knowledge, I'm not, sir.
All right. Well, let me show you a picture here. Cotton Eye Joe, where's that?
It's on 2nd Avenue, sir.
2nd Avenue is not an approved route, is it?
Not to my knowledge. Not on regular route unless they have special compensation to move.
Let me show you a picture of Matthew Clark of Hat Creek. Is that a violation, what you see there?
That would be considered a violation, sir.
You see why I asked if you had facial hair? See the gentleman on the sidewalk?
Yes, sir.
Is that you?
I don't think that's me.
Well, I don't know.
That doesn't look like me, because I sure don't have, that's got a lot of facial hair. Not that I want you touching me, but you're very welcome to feel my face, or if you'd like to. You know, I've got a little bit on my chin, a little bit under my nose, but that's about it.
Well, this is a clear violation. Do you see the date here? And I will have some testimony that this date is the date that it was taken. What's that date?
The date is March 3rd, 12.
Same day?
Yes, sir.
Does it have a time?
Time is 15:24.
Which is
3:24, yeah.
All right. Where were you at 3:30? Were you through taking pictures of Johnny?
No, sir. I was still
Mr.
sitting
Blackman,
at
it
that
would
same
certainly help
area.
if we could see what you're referencing.
I beg your pardon.
If I may say so, also, at no time was I up there next to the carriages on that date. So that definitely is not me.
Well, we've got a lot of these, and I won't trouble you with all of them, but do you recognize this carriage in that photograph?
No, sir. Not without being able to get a close-up on that signage back there.
Well, it's got his back to the camera, obviously. That is a carriage, though, pulled by an animal, a horse, I presume. Is that right?
That's what it looks like, sir.
See the courthouse where we are now, up the street, leads at 2nd Avenue. Does
Correct, sir.
Any citation issued?
No, sir, because I've never seen it. I didn't see it that day.
Mr. Lee Rader?
Again, sir, without them standing right here in front of me to say...
Mr. Blackburn, can I please ask, how is this particularly relevant to the matters that are before us?
Yes, you have a duty to enforce the laws equally, and if there's selective enforcement of the law, that is, well, it's a constitutional violation among other things, but it's unlawful. It's a defense to any prosecution.
Mr. Blackburn, I think that we get the point, but do we have to go ad nauseum at things that you may be alleging to be violations that aren't particularly relevant with this matter that's before us?
Mr. Chairman, I've never been in a hearing where 2 photographs were ad nauseum to anyone. I've looked at nauseating photographs, but not 2 being ad nauseum. Tell you what,
I'm just struggling on the relevancy. But, I mean, we're considering it. We're certainly willing to consider it. I have your point now.
All right. Well, then this last one I asked you about, I'll stop with that. Is that looks like a carriage on Lower Broad having turned onto First or Hermitage Avenue, whatever it's called at that point. Is that right?
That's what it looks like based on the building that's behind him.
And that's off Route 2, isn't it?
That would be very close. If he came straight up on Broadway and been in like that, if there were a lot of horses there, it would not be a deviation. If he's coming off of 2nd, it would be, sir.
If he blocks traffic, is that a violation?
Yes, sir, that would be.
Is there a blockage?
He is in the intersection, sir. And
okay. I have more, but Mr. Chairman, you've made your point, and I accept it. We have then how many carriage operators operating in that vicinity?
Operators, sir? Gosh, I'll be honest, I don't know, 4 or 5.
4 or 5?
Sure.
How many of those, well, you already answered me. That day you issued citations to only 1?
Correct, sir.
Now, are you not aware that police officers will direct carriage operations on some occasions in order to, especially their termination of Lower Broad, for safety reasons?
Sure, absolutely.
And that includes U-turns?
That would be true.
You don't have to come back to the Traffic Parking Commission to do that?
No, if a police officer directed you to do that, that would be perfectly legal.
Do you think it's important that the law be enforced the same with regard to each carriage operator?
Yes, sir.
All right. Thank you, sir.
You're quite welcome, sir.
Just a couple of follow-up questions, Mr. Morris. With regard to the rule involving the prescribed routes for horse and carriage drivers, is that a commission rule?
I think that's a parking. It may be a combination of commission and parking. If you're asking me the history of that, I don't know which one of them actually does it.
And I don't ask you the history of it. Mr. Chair, I'm not sure if this is in your packet or not, the copy of the horse-drawn carriage rules that apply. I believe there are 9 of them.
Yes. They are in the record.
That
is a part of the record.
Mr. Morris, do you have knowledge, one way or the other, as to whether Sugar Creek Company has in fact had prior violations before this commission?
I've been told they have, sir.
Okay. You have not been a part of presenting cases along
No,
those
sir,
lines?
not at all.
Okay. And again, Mr. Chairman, I believe already part of your packet, and thus the record, is a copy of 4 prior documents involving disciplinary action against the Sugar Creek Company from this commission between 2008 and 2011.
Yes, it is.
Very well. On March the 2nd...
Mr. Blackburn, do you have those? Do you have those or need those to review those? The prior violations of Sugar Creek?
Oh, I probably have them. I would like to review them. One of them, is this where one of them had to do with solicitation? Is that what you're referring to?
1 year.
Those are the 4 that are in the record.
Mr. Morris, on March the 2nd...
Third.
Sorry, March 3rd. March of 2012, on the date of these incidents,
Okay.
did you see any police officers directing the horse-drawn carriage to make the U-turns that you saw them make?
No, sir.
No further questions at this point. I'll be glad to step aside and certainly entertain any questions from members of the board that may be appropriate.
I don't have any further. Thank you.
Do you have any witnesses, Mr. Blackburn?
I do.
Mr. Michael, that is that concludes your presentation.
Conclusion. I would like to note that if the board, after its deliberation, does in fact find that these represented violations on that day, we would like to be heard very briefly, to the tune of 60 seconds or less, on the question of appropriate disciplinary action. But that's only in the event that it becomes necessary.
Yes, sir. Mr. Blackburn.
Would you tell the commission your name, please, sir?
My name is Clinton Lemoyne.
What kind of work do you do, Mr. Lemoyne?
I drive a carriage in Nashville.
For whom?
For myself.
All right, so you're not an employee of Mr. Smith?
No, sir.
Are you familiar with Mr. Smith and his operation?
Yes, sir.
All right, are you familiar with this area of Lower Broad because you operate carriages of your own there?
Yes, sir.
Now, what is the practice among carriage operators generally about making U-turns?
Everybody does it.
Everyone does it?
Yes, sir.
Have you done it?
Yes, sir.
Have you, where along this route have you done U-turns?
Several places in the, right there at 2nd and Broad, at 1st and Broad. I've done it coming out on Broadway at 5th, at Broadway at 4th, just all up and down.
Have you ever had a citation issued to you for doing a U-turn?
No, sir, never.
Have you seen how Mr. Smith operates his equipment?
Yes, sir.
Is he safe?
Yes, sir.
Tell the panel, please, what you mean when you describe him as having a safe operation.
He always has working lights. For example, his horses are in good health. His drivers follow basic rules of the road.
Are you familiar with the Hat Creek operation?
Yes, sir.
Have you seen them operating outside of this zone, specifically on 2nd Avenue?
Yes, sir.
Have you seen them make U-turns?
Yes, sir.
That's all. Thank you.
Is that your only witness, Mr. Blackburn?
Unless you have questions of Mr. Smith, according to the letter, it indicated that you may have some questions of him. But yes, that's our witness, given these restrictions.
Mr. Michael? No. Commissioners, do you have any questions?
like to ask one quick question, Mr. Blackburn. In your estimation, how many people a day you think drive under the illegal auspices of driving while intoxicated? Just as an example in Davidson
You're
County.
seriously asking me to estimate, to speculate how many people are drunk drivers?
Well, then let me ask you this question. Do you think everybody gets caught?
I think a substantial number do.
Do you think it's unfair?
If you picked out a certain class of people, which has been done in this community. If you pick out a certain class of people, then you're violating the law. I think once Chief Surpass decided that a main element of enforcement was going to be traffic stops, there were a lot more people stopped.
I would agree with that, sir. But all you've shown me so far is that other people do it too. So
what I've
that's
shown
all
you
I'm
is that
saying.
everybody does it, but one is punished. I hope you can get the significance of that.
Okay. Thank you.
So, Mr. Blackburn, is that a concession to the incident right now before us that the violation was in
here? You haven't even proved a specific.
That was a question. I'm trying to get the scope of your.
We don't have a burden of proof, so no, we are not conceded anything. We have proved that it is a standard practice of all of these folks to do those U-turns on Lower Broad.
Yes.
That's the only evidence you have before you. We don't have a burden of proof here.
Well, let me say one more thing.
I believe that the question.
You just had one person come say it. You didn't prove it.
I think you're a little confused with due respect. But one person's testimony is proof of any fact in all courts in America.
Well, this is not that type of court, so.
But you said there's no proof. Proof is one of those legal terms that you don't wish for.
So then the commissioners, or the inspectors would also be proof.
Well, an inspector by himself is not proof. His words are proof. Now, if this were offered under oath, then it would be proof. Okay. We don't have any proof here.
Okay, so I just want to do eye for eye here.
Well, what you want to do is quarrel with me over these things, and I'm happy to quarrel. I quarrel for a living.
Yes, you do.
I'll be happy to do that. But I wish you could see what you're doing here.
Mr. Blackburn, the only question that I'm trying to get my hands around for the purposes of the commission's deliberation, which are the issues that are before us presently. And we have not specifically heard any testimony where you deny the allegation that you made the U-turn on the specific day in question. We have not received any rebuttal to the inspector's statements that I've seen, and I want to make sure that that's not a concession to these specific incidents. And if it is, then we would need to know that as well. And if you're challenging us on jurisdictional grounds, then so be it, but we would need to know the facts that are before us. And you can understand our point with wanting to clarify what your position is regarding these specific facts.
Well, no, I take your point, Mr. Chairman. I certainly respect that. But I think it's important that you also respect our point of view, and that is we do not have a burden of proof.
We understand.
In fact, that's why you offered the first evidence.
No, we didn't offer anything. We did not offer anything. Just so we understand that.
I sat here and cross-examined the witness, but be that as it may, what has occurred here is that an inspector whose credibility is seriously in question has testified without being administered an oath that day, despite all of this traffic, he saw one person make a U-turn. And he then doubled up on it. He then took one U-turn and turned it into 2 citations. When that was presented in the environmental court, as he calls it, in the General Sessions Court before a referee who's authorized to take that evidence and find those facts as a matter of law by private act, he testified, and then that was dismissed. Every court in Tennessee, that's res judicata, that's jeopardy. It's as though you have a jury who's sworn and then you nolly the case. That case is over forever. Now we have these double charges offered in a discriminatory manner being proffered against him today without any evidence even of the specific violation itself, just that it's a U-turn. Now, if that's how we do business, that's how we do business. It'll just have to be debated elsewhere.
But we are going to acknowledge that you have not presented any evidence that he did not do the U-turn, though, correct?
I am not going to stipulate a fact for the benefit of this body.
I'm just trying to understand. No, Mr. Blackburn, we are really just trying to understand. That's part of the process, and I believe that's a part of your job as a representative for us to understand what your client's position is. That way we can really fully get our grasp on it. And you've done a good job as far as for telling us the position. I just want to make sure, because these are issues that may be concerning to us. Whether your client contests he made the U-turn or not is a fairly simple question in this matter, I think.
The simple question is this. When charges are placed by a governmental body, who has the burden of proving those charges? It is not the defendant.
Absolutely.
All right. Now, what you're asking me to do is to stipulate to a point that's not my burden on behalf of Mr. Smith.
Mm-hmm.
For about 15 years, 90% of what I did was defend car wreck cases for insurance companies. I was never asked to admit anything. Mm-hmm. Now, we're not here in a kind of formal proceeding, mm-hmm. as you've indicated. I understand that. I'm not quarreling with you about that. Don't misunderstand. But when you're trying to deprive a citizen of this community of an interest in property, it's not his burden to prove his innocence. It's the party trying to do that. It's their burden to prove it. Now, whether that's proved or not is for you.
That is for us to deliberate.
Pardon?
That is for us to deliberate.
That's right.
I mean, that's why I want to know your full factual position, because we just wanted to clear the air so where I understood your position. We do understand your position. Thank you. Mm-hmm. Commissioners.
Is there any further testimony?
Is there any further testimony, Mr. Michael?
Nothing further on the merits of the matter, Mr. Chairman.
Commissioners, any further questions that can aid our deliberations at all?
I think I can like to add some points and maybe vocalize my interpretation of the situation here. I understand Sugar Creek's position that this commission doesn't have jurisdiction to hear this matter because it's already been heard in environmental court and dismissed on some grounds, although it's not really clear what those grounds of dismissal were. I disagree, though, with Mr. Blackburn that this is a double jeopardy. This commission is not vested with any power to deprive someone of property.
Absolutely.
We're here to decide if Sugar Creek should have a license or should continue to have a license or act upon that licensure in some way, either through probation or suspension or no act at all, and just let them to continue to operate with a license. That is not a piece of property. That is a privilege. So I don't think the commission should be concerned about the double jeopardy issue or the fact that we don't have, the commissioners do not have jurisdiction. I agree with Mr. Blackburn that it is the burden of Metro to prove that there was a violation of its laws, and I agree with Mr. Blackburn that he does not have to concede anything with respect to the actual violation itself, but the absence of any proof on his side would lend the balancing of the scales in favor of Metro as to whether an actual violation occurred.
Commissioners? Mr. Michael, you asked for a couple of minutes to discuss.
Essentially, just in the event that the board does contemplate disciplinary action, we would only point to the fact that this took place during a period where Sugar Creek was on probation from this commission, which had been instituted in late June of 2011. Obviously, still in one-year probation would have obviously still been intact in March of 2012. To the extent that bears any weight on the commission's consideration of what to do if in fact you determine that there was a violation in this instance. Your packet includes copies of the 4 prior disciplinary actions against Sugar Creek, all in a somewhat recent history, I think dating back to 2008. We're not going so far as to recommend what you do. That's not our place, that's yours. But instead, just to point out that these are factors that should be relevant in your consideration.
Mr. Blackburn, do you have any rebuttal or want to make any further statements.
Well, I can respond to that. You had, it ought to be more than passing strange that as the probation period neared an end, that was laid out by this commission, 3 months, fully 3 months after this incident, an individual then filed ordinance violation citations, all on the same day, doubling up on what the violation was right before that. Now, if we're going to compare this to like being on parole and violating, then it needs to be well understood that at the time these ordinances were brought before the referee and were voluntarily dismissed by Metro, which is because he was sworn a dismissal on the merits. That's what happened. They didn't respond to our brief. We were outside the probationary period then. As we stand here today, Mr. Smith has been found guilty of nothing. So it cannot conceivably, legally be that he is now in violation of probation which has expired. That's true everywhere in Tennessee. If you look back over some of those violations, they were, I think the most serious one was that one time he didn't have lights on the back of one carriage. He had an explanation for that, and you found that he was guilty of that, and we're not quarreling about that here. One of the citations was he was soliciting. He was charged with solicitation. This board has no right under the First Amendment to prohibit solicitation. And I would strongly urge you to reconsider that going forward. That is a commercial speech First Amendment right. It's why we are subjected to these lawyers advertising on television, which I despise. I don't despise them, I despise the practice. That's commercial speech. You have no authority to do that. And if you base an enhanced punishment on Mr. Smith based upon an alleged violation of this solicitation requirement, that's another constitutional deprivation. You know, Mr. Smith runs clean carriages. Has he ever been in an accident? We're not here talking about an accident. We're not here talking about any individual being inconvenienced or traffic being blocked. We're not here with anything brought to your attention by a genuine police officer. We're here because one person out of all of these individuals found that Mr. Smith, as compared to everyone else, was making a U-turn when it's a common practice among all of those operators. These things are important, but some sort of idea that he was on probation at the time he's found guilty of something is incorrect. As we stand here, he's been convicted of nothing, and he's not on probation today.
Thank you. So, commissioners. Mr. Blackburn, have you, I don't have in front of me the definition of vehicle. Have you looked at that to determine if, in fact, a horse carriage is a vehicle?
In what context?
In context with respect to the Metro Code for turning?
Well, no. I mean, that's not been brought up by anyone, including the Metro attorney at the hearing, as to whether this is a vehicle. The violation he contends occurred has to do with that. If it's not a vehicle within the meaning of that statute, then by definition he's not violated it. You'd have to look for something else.
Might I say something?
Yes.
Mr. Blackburn, I agree with you that you are a very good arguer. You are. And a good attorney. I'm not an attorney. I've been a plaintiff, though, however, in traffic court. I could not imagine my defense in traffic court being, yes, I was speeding, but everyone else was. Also, I have to tell you that having read all of the information that was provided to me before this meeting today and listening to everyone today, I personally am convinced that the inspector acted on what he believed to be an infraction of the law, and he had the right to issue the citations. If he had not seen others do it that day and didn't issue citations to them, perhaps he needed to look further. I don't know. I can't answer that. But I can also say that if a police officer is on the interstate and sees 10 cars speeding and stops one, a defense could not be, well, everyone else was doing the same. Actually, I tried to use that defense a couple of times, and it doesn't work. Trust me, it doesn't work. So personally, having listened to everything, I feel confident that there was a reason for the citations to be issued. How this commission acts on that will soon see. But I haven't heard anything today that would convince me that it didn't happen. I have to take a look at these people who are professionals and who are out there on a daily basis trying to ensure the safety of the city and the people and the residents of the city. And I have nothing against any company that's out there. I think that it's a great asset that the city has, is that we have these horse-drawn carriages. But I have to agree with the inspector. If he saw a violation and he issued a citation, it is just, I feel that he had the right to do that.
Do you wish for me to respond?
Not necessarily, but surely you may.
Well, you're certainly correct that you can't drive down I-40, get pulled over going 80, and say everybody else was going 80, which we've all done. Mm-hmm. I suspect everyone in this room has done that. That's true. However, any governmental body that enforces the law has a number of duties. One of those duties is to have only those persons authorized by law do that enforcement. This gentleman did not have that authority, and he did those citations. And if you want to look at that, look at the excellent memorandum which our chief of police wrote to that effect. Look at the fact that on this very agenda, you had a letter read excusing them from these violations of the law because they didn't know, because they didn't understand it. They didn't understand that it was a violation of the law. I heard this read at the beginning of this matter. I assume that's going to be in the minutes.
That was something very different, though. That was in carrying a weapon and a badge.
It's in pretending to be a police officer. It's, according to the chief of police, it was a crime. It's not very different. Now, so you have a person then acting ultra vires, a person who had no authority to issue any citation. That's the beginning of it. The second thing becomes, what is the credibility of this witness before any finder of fact? Well, is that credibility affected by selective enforcement or favoritism? There was a time, I'm 65 years old, I can tell you there's been a time in this country where ethnic groups and women have had laws selectively enforced against them. I've seen it myself. Anyone my age has. That's a violation of a duty on the part of the body that's doing the investigation. Now, if this happens, what we've shown you is that all of these entities routinely do these U-turns. We've shown you pictures of these people from Hat Creek off these routes, and it's a routine matter. Now, how does it come to be that Johnny Smith is the one who's singled out for prosecution? Not that it excuses a violation if one were proved, but that is a selective enforcement of the law, and that is unconstitutional here and all through America, binding on this board and everybody else, all of us. That's the point. Now, if everyone does it routinely, then how does it come to be that this pretend cop can only find one? How does that come to be? You heard him admit that he's ridden in the Hat Creek carriage equipment. used equipment instead of vehicle. That he's ridden in that? Why? What kind of relationship between this gentleman and through him this body exists with Hat Creek? That's going to be explored one day. And how long? Well, where are the citations? Why is only Hat Creek having these citations written? There's some explanation. You know, there was on this agenda numerous complaints about abusive behavior by Hat Creek employees. For reasons, I'm accusing no one of anything, but it's not on the agenda now. It was removed. It could be because someone on their behalf did what I did before, and that is requested a change. So that could very, very well be. But the fact is, it's removed. You know, there's been vandalism. I have a former police officer here, in case this was discussed, who has investigated this. There are going to be some criminal charges filed because of property destruction and various acts that have been conducted. The thing that had to do with Hat Trick, I'm missing hockey now. I really do. Hat Creek, was original on these original charges. There were charges that Mr. Smith had said ugly things to these poor fellas. I'm sure they're frail. That was taken off. When this was scheduled with this hearing today, those disappeared. Where are they?
They have not disappeared, but nevertheless, can we keep it on this actual issue, please? You can wrap up.
I'm just responding. Thank you.
All right. Transportation Licensing Commission, we have to understand that pursuant to the Metro Charter that we do have the authority and the power and the duty to enforce the rules and the regulations concerning vehicles for hire. And I personally think that I truly appreciate the service that inspectors do. I appreciate the horse-drawn carriage industry itself. And I don't think the inspectors are pretend cops. We appreciate your service. But nevertheless, we have a matter that's before us and commissioners. We're going to close this off for deliberations. And if anyone has any motions, we will entertain any motions on this particular issue.
Mr. Chairperson, I'd like to hear from the Metro lawyer as to what he would recommend for a possible punitive measure with respect to punitive is not the right word, but as possible measure as a consequence for the violation if we find there's a violation.
Members of the Commission, I believe the practice has been in the past often to defer to staff, namely to the director, acting director, with regard to the recommendation that they have on that. However, we would, on behalf of the Metropolitan Government's legal department, point to the fact that you have a June 2011 one-year probation that was put in place. Approximately 3 months later, a September 2011 disciplinary action against this entity that involved a suspension, a date which I do not recall without looking at the document. This then would constitute, if found guilty by this commission, a second violation during that one-year probation, not, as has been suggested, waiting 9 months to find one violation, but waiting 3 until they stumbled into one, and then 6 months later, yet another. Again, if the commission finds them guilty in this instance. At the end of the day, though, while we do obviously have safety concerns, which is the heart of what the Transportation Licensing Commission is concerned with, whether it be with regard to wreckers, taxi cabs, or the horse-drawn carriages, the guy's not out there popping wheelies 60 miles an hour. Not trying to overstate what he did. What he did was a violation of the rules, we contend, and of traffic laws, we contend. And as a result, it has to be taken seriously, but we want to be careful to put it in some perspective. This may not be something that you think rises to the level of a complete and total revocation of the entity's certificate, I guess it is the proper phrasing, to do business here in Davidson County. Frankly, I think that would have a hard time sticking. We do think that it's possible that some form of suspension is appropriate. The amount, that's for the commission ultimately to determine. But again, we would just encourage to take some consideration of the fact that it was a series of U-turns. It's a mistake. It's a violation of the rules and the Metro Code. But we're not trying to suggest that this is some horrible, awful crime that should automatically get somebody's certificate revoked. Now, I hope that doesn't sound like I'm splitting it too much down the middle, but we wanted to be fair toward the entity in terms of the recommendation that we passed on to you. The only other note, and I think this may be important just for clarification purposes, there was some discussion from one of the commissioners with regard to the issuance of citations. And Mr. Blackburn capably responded to that, but I think it's important to clarify that the citations were the actual tickets, so to speak, that went to environmental court. What is then brought to you, the commission, are merely charges brought by the staff so that you get a separate opportunity to make your determination on that. The questions about whether or not the inspectors have the authority to issue citations is a very specific one that has to do with citations that were issued to environmental court. I've never encountered any question as to whether or not the inspectors can come to you and make a report of what they've witnessed and then give you the opportunity to determine what to do about that. Thank you for your consideration.
Thank you. Commissioners, do we have any we would like any discussion, any deliberation, any motions? We will entertain any motions at this time.
Can we ask for a recommendation by the director?
We do have a wide variety of leeway, and I certainly think that we can consider a recommendation from the director.
Staff takes very seriously this particular issue, and any issue that could deprive any business, whether it's one of our carriages, our wreckers, our towing services, our limousines, or our booting companies. When you consider revocation, it's putting a lock on the front door. So we take that very seriously. We take equally serious any suspension, probation, or any other discipline that's issued by this commission, because we particularly are concerned about public safety. I've thought a lot about this because this was one of those issues I inherited when y'all allowed me to come back and serve you. Mr. Smith was on probation at the time that it was committed. I'm not a lawyer, so I certainly am not going to argue any of the legal merits about when's probation, when's not probation, but the probation period was at that time. I think what I would recommend is I think a suspension is appropriate. I think I would suggest a suspension of 1 month. I would suggest, if I can, to do that in the month of January of 2013. That would give Mr. Smith plenty of time to do what he might need to do in terms of getting his company ready. I would encourage him to use the month of January to do work, and I know the carriage industry as well as I know, maybe better than all, because they certainly, both Clint and Mr. Lemoyne and Mr. Smith, were two of the original carriage operators when we actually began regulation back in 2002. So I would recommend suspension for 1 month, again, to commence in January, to end in January, and a 12-month probationary period that would commence when he began service again on February the 1st, 2013, to complete on February the 1st, or January 31st, 2014.
Thank you. Commissioners.
One thing I guess I should have done, just to make sure, again, I did not go through clearly. You have right from the top to the bottom, which is in terms of revocation all the way down to finding no action. You could include anything from probation to suspension on time periods that you choose.
I appreciate the recommendation. I do personally feel that 1 full year is a little harsh.
Would you like to make a motion?
I'd like to hear from other commissioners and what their thoughts are.
I do find that there was a violation that occurred, and taking the fact that Sugar Creek was in probation or in the probation term, I'll make a motion. I move that we place Sugar Creek on suspension for 30 days beginning on January the 1st, 2013, and place them on probation beginning on February 1st, 2013 for a period of 1 year. And that's my motion.
We have a motion on the floor. Do we have a second?
I'll second.
Motion's been moved and seconded. All those in favor say aye.
Aye.
Opposed?
Nay.
Nay.
Interesting.
I understand the charges. I'm just a little. I just hate to stop someone from making a living. Here's a man who makes a living doing this, and I think that he now understands what's going on, and that maybe people were a little lenient, maybe inspectors were a little lenient, and everyone else was doing it, and I understand that. I hate to take the. I just think it's a little bit harsh. Perhaps we do.
Oh, no. Keep saying.
I was just thinking maybe weekends for a month or something where he'd feel it, but he'd still be able to make a living during that time.
May I ask a question to the director? In January, especially with the temperature rule for horse carriages, how many days do they actually operate on average?
I would probably be hard-pressed to answer that question. Again, if the weather's good, it's right. People ride carriages when the weather's good.
Can we ask Mr. Smith that? See why we couldn't. Mr. Smith, can you ballpark that?
What was the question?
On average in January, especially with the temperature rule, how many days do you operate?
Mr. Blackburn, you don't have any objections to this simple question?
No. I would ask the same thing. They're asking how many days you would typically operate in January, understanding that we don't know what the weather's going to be.
That varies. It just depends on the year. Like one year, about 3 years ago, the convention center had a whole lot of conventions during January. We operated probably 10 to 15 days, but then there are some days, or some Januaries that we don't operate at all. Right. January is our worst, slowest month.
That's what I was thinking.
Yes, sir.
Thank you.
And I believe that's why Mr. Fields made it in his recommendation that January would be a good month for suspension, as it wouldn't impact.
Okay, Mr. Wallen, if you make that recommendation again, I might change my vote this time. If you make the motion again, I just want to go on record as saying, I know you said before, Mr. Blackburn, that and you said it in passing that he might have had words with other drivers after you talked about the solicitation. I would say that if it were the words on drivers, I would be much more apt to be a lot harsher in my decision, because I think that is a lot worse than making a U-turn in the street. But given that it's a U-turn citation, I was wanting it to, I thought it was a little bit harsh, but under the circumstances, knowing that January is probably the slowest month of the year, if you make that motion again, I will change my vote.
Just cleaning this matter up really quickly, that the previous motion did fail. And so just so we know that, so there's no further motions that are on the table right now, and we will entertain any motions from any commissioners at this point. Well, excuse me.
If you're wanting to address the previous motion, you'll need to take a 2/3. You'll have to have a 2/3 vote, and then you can bring up that same motion again, because the motion already did fail.
Okay.
And before we make any motions, I wanted to make an open comment and express why I voted no as well. I agree with my co-commissioner here that I felt that the consequence for the illegal U-turn was too harsh, and I don't believe that a suspension of 30 days is warranted. I would recommend, a 10-day suspension at the end of January.
Is this a motion?
Well, I wanted to make those comments before I make a motion, and if there's anyone who has a response to that, then I can make a motion.
And I want to make sure of one thing, that we don't have two potential violations here. One is not adhering to the prescribed route by Public Works, which should be separate from an illegal U-turn, which is really what was in question. I don't think am I missing something?
I hear what you said. I'm sorry.
That there are two different issues here. One is that they did not run the prescribed route as prescribed by Public Works, and two, that there was a violation regarding a U-turn.
That is a question for John Michael. I would say procedurally, though, before you go into discussion, that you need a motion properly seconded, and then open up for discussion. And if you want to after that amend the motion, then you can entertain amendments.
Never mind.
I believe that
Yes, it's the question.
Yeah. I believe that you're correct. But Mr. Michael, you can actually answer that question, but I do believe that to be correct.
Yeah, you have one set of facts.
Yes.
You have one incident. The city has presented proof that is intended to prove, at least, that the one set of facts, that incident constituted violations of two different applicable rules. But the board, of course, is in a position to take action either way.
And so, and we do have the authority and the discretion to whether, want to lump everything together or separate them out or whatever, but we need a motion on the floor because the previous one did not pass. And if we have any new motions, we will certainly entertain new motions, or we can renew the other motion, but that's going to take something else, a different method. Do we have any new motions right now?
I'll make a motion. I move that the commission find that Sugar Creek violated Metro Code 12.16.170, which prescribes turning to go in the opposite direction, and allowing that only when such movement can be made in safety and without interfering with other traffic. Based on this violation, I move that the commission suspend the certificate for Sugar Creek for a period of 10 days beginning on January 20th, 2013. And also, once that suspension is lifted on January 31st, 2013, that they be put on a period of probation for 6 months.
We have a motion on the floor for a 10-day suspension beginning January 20th and a 6-month probation at the conclusion of the suspension. Do we have a second?
I second that motion.
Motion properly moved and seconded. All those in favor say aye.
Aye.
Opposed?
Nay.
Motion passes. Any further considerations on this issue? We are clean. Do we have any other business, Mr. Fields? Well, I will gladly entertain what I believe to be my favorite motion.
Motion adjourned.
Second.
All those approve? Aye. Adios.